Respondent Cornelia Davis. I should mention, Your Honor, that Davis was not feeling well yesterday, but she's going to do what she can to get herself onto the Zoom to see what's happening. But she's not going to say anything, obviously.
Is the date and time set for closing arguments? On behalf of the disciplinary counsel, would you please present your argument?
Yes, thank you. Good morning. Just 2 months after Judge Davis first took the bench, on May 8, 2017, he held a hearing regarding a motion for relief from judgment in a landlord-tenant matter on the very day the motion was filed, meaning that the plaintiff, Detroit Real Estate, had no opportunity to file a response. At the hearing, Judge Davis declared that an eviction notice was a complete lie used to intimidate people, and she doesn't like lies or people lying on the court. She then decides that attorney Diane Wyrock is to bring someone from Detroit Real Estate who has a checkbook because somebody is going to pay some money. So Judge Davis has clearly prejudged a matter where there has been no evidence or explanation before her. And at the May 24 show cause hearing, provides no real opportunity for Joy Eck to provide any explanation. Instead, without the benefit of a hearing where evidence is presented, Judge Davis determines that Ms. Eck engaged in fraud, that her conduct was intentional and purposeful, and that she wanted to subvert the law. Now, this was just the placement of an incorrect eviction notice that she determined was a business practice. Ms. Eck is then fined $3,000, and how this amount is determined, we don't know. In punitive damages, which don't exist in a contempt matter. And Judge Davis then goes on to threaten to put Ms. Eck in jail if she doesn't make payment that day, something Ms. Eck didn't say she wouldn't do, and continues to berate Ms. Eck. A few months later, at the end of August 2017, Judge Davis witnesses someone, not Myron Bell, leave documents at the door of her aunt's residence. Judge Davis acknowledged that she made an assumption about the identity of the process server. The next day, Judge Davis sends an ex parte email to the judge handling the matter, Judge Millender, and to Judge Miller, stating that Mr. Bell left the documents, excuse me, at the wrong address, and expresses concern that Mr. Bell was not fulfilling his statutory requirements for service, and that this was his common practice. Myron Bell and Judge Davis had never even met each other, nor had Mr. Bell ever been in Judge Davis's courtroom until he stepped foot in a courtroom in Southfield on July 7th. Now, admittedly, the proof of service is inaccurate regarding the day and the time the documents were attached to the door. However, the plaintiff's attorney had placed the wrong address on the documents, so the case was dismissed by the attorney on August 31st, and the matter should have been over. Unfortunately, when Judge Davis returned to work following a medical leave on September 18th, she announces from the bench that the attorneys are not to use Myron Bell as a process server, or she would dismiss their case. Once again, Judge Davis is announcing that she's prejudging cases that will come before her. Judge Davis then does proceed to dismiss or adjourn cases solely because Mr. Bell was the process server. And on September 25, 2017, Chief Judge Blount had to get involved and entered an order stating that Judge Davis must cease and desist from dismissing cases for lack of service based solely on the identity of the court officer or process server, and shall reinstate any cases that had already been dismissed, but Judge Davis simply ignores the order. Instead, Judge Davis continued to dismiss or adjourn cases under the guise that the plaintiffs had failed to attach a copy of a lease or deed to the complaint without determining whether a lease even existed. One time, Judge Davis is told there was no written lease, and she won't allow the attorneys to make a record. Judge Davis's disdain for her chief judge's order came through loud and clear when on October 6th of 2017, Attorney Frederick Coleman appeared before her. This was regarding several landlord-tenant cases. Judge Davis on the record states what her policy is, that she does not believe anything Myron Bell says, and that she doesn't care what the chief judge or anybody else at court says. When Attorney Coleman points out that due process would have Mr. Bell come in to testify whether he had served documents or not, that the defendants were not even present in court, and he requested that a default be entered, Judge Davis refused. Even though she doesn't know if the defendants had been properly served or not, Judge Davis simply asked when Attorney Coleman would like to come back to court after properly serving people. Then, just 5 days later, Judge Davis conducts a hearing involving Jerry Johnson, who purportedly served a summons and complaint on Nicole Thomas. After hearing basically, yes, I did serve it, no, I didn't get it, Judge Davis does something extraordinary. She makes a phone call from the bench to the tenant's alleged employer. She doesn't swear the witness on the phone. She doesn't allow the parties to ask any questions. And after hearing from the person on the phone, Judge Davis accuses Mr. Johnson of not caring about due process rights, lying on the proof of service, and lying on the record under oath. Mr. Johnson is given no opportunity to defend himself against these serious allegations, just like Joy Eck, and in essentially a sham hearing, finds Mr. Johnson in contempt of court and sentences him to 5 days in the Wayne County Jail. Now, Judge Davis also threatened both the landlord and her husband with jail time simply because they were asking legitimate questions at that same hearing. The following day, Judge Blount learned that Mr. Johnson spent the night in jail, ordered the transcript, and owing to any contempt not being direct, ordered Mr. Johnson released from custody, ordered that he be issued a personal bond, and ordered his appearance before Judge Baltimore the following day, where Judge Baltimore found that no contempt had been satisfied and dismissed the contempt charge. Now, it is unfortunate that we were not able to hear from Ms. Eck, who was sick, and Mr. Johnson, whom we could not locate, because it's important to put a face on and give a voice to those who were treated so unfairly and harshly by Judge Davis. However, the crux of the charges for these first two counts are failing to be faithful to the law, failing to maintain professional competence, and persistent incompetence in the performance of judicial duties in violation of Canon 3A1. There's also failing to promote public confidence in the integrity and impartiality of the judiciary in violation of Canon 2B, failing to be patient, dignified, and courteous to litigants, witnesses, and lawyers in a courtroom in violation of Canon 3A3, for making pledges, promises, or commitments that are inconsistent with the impartial performance of adjudicative duties in connection with cases likely to become before her in violation of Canon 3A7, and most especially for making premature judgments in violation of Canon 3A12. I also want to address the lack of training claims that have been asserted in these counts, because Judge Davis did receive new judges training. She attended the Michigan Judicial Institute pre-bench seminar on November 16, 2016. She did not attend the new judges school in January 2017 because of illness, but she acknowledged at the hearing to receiving the materials that month. She participated in the new judges orientation at the 36th District Court in mid-March of 2017. Admittedly abbreviated, as Judge Blount stated, because she had missed the original orientation. However, Judge Blount testified that she believed Judge Davis sat with Judge Millender the presiding judge in the landlord-tenant division for about a week, that she also sat with Judge Jefferson, who presided over the civil division, and with Judge Giles, who presided over the traffic division. Now, Judge Blount also believed that Judge Davis sat with Judge Baltimore at the Frank Murphy Hall of Justice. In addition, we know that on March 14 of 2017, Judge Davis received an email with a link for access to MJI bench books. And Judge Davis also attended the new judges conference on March 30 and 31 of 2017. These are the normal seminars that are attended by new judges in their first year. The conduct respecting counts 1 and 2 cannot be classified as mere legal error, as has been done in the answer to the formal complaint. Given Judge Davis's propensity to make assumptions, to decide matters with no properly admitted evidence, to prejudge matters before her, and to ignore Chief Judge Blount's order regarding Myron Bell, it simply can't be said that the decisions in these two counts that were made regarding counts 1 and 2 were made either in good faith or with due diligence, as is required under MCR 9.211B. In response to the treatment of Myron Bell and Jerry Johnson, Chief Judge Blount also did something extraordinary, which she issued an order on October 20 of 2017, prohibiting Judge Davis from presiding over 36 district court matters. And this was done in consultation with State Court Administrator Milton Mack. The order also required Judge Davis to report to work on a daily basis. Because Judge Blount did not know if Judge Davis was otherwise in the building, Judge Blount sent an email on November 1 of 2017, making a very reasonable request that Judge Davis confirm her reporting to work each day by submitting her arrival time to Chief Judge Blount's office. Judge Davis refuses. And then, commencing on November 6 of 2017, she begins to send a series of Bible verses instead of simply reporting her arrival time. And these certainly aren't the love thy neighbor Bible verses. Instead, they're perceived as threatening, as Judge Blount described, and as wishing harm on someone, as Judge Paruk noted. As the emails continue, Judge Mack is preparing a performance improvement plan. And we heard from Judge Paruk state several times that SCAO's goal was to make Judge Davis the best judge she could be. But there's resistance. Judge Davis won't initially sign the performance improvement plan. And even after her November 30th meeting with Judge Paruk, she sent yet another biblical email. Nevertheless, Judge Davis did ultimately agree to comply with the personal improvement plan, and she has a mentor, retired Judge Edward Thomas. And in about the middle of 2018, Judge Davis is returned to the bench. Unfortunately, the problems didn't stop. Judge Blount entered a directive that Judge Davis was to work a felony docket on December 26, 27, and 28 of 2018, but Judge Davis did not appear for 2 of those days and did not obtain coverage. So she's then not showing up for work in January of 2019, and Judge Paruk contacted Judge Davis about this. On January 23rd of 2019, Judge Paruk then made some amendments to the performance improvement plan, but not having heard from Judge Davis, he sent an email to her on January 25th, asking for some information. And on the 28th, Judge Davis finally responded, but in an entirely disrespectful manner. She repeatedly tells Judge Paruk to find someone else to harass, and then made some bizarre reference to the ghosts of judges past exchanging their black robes for white ones. So we heard in detail from both Judge Blount and Judge Peruke how Judge Davis's conduct impacted the court's discharge of its administrative responsibilities. That is, Judge Davis failed to communicate her attendance in a timely manner on numerous occasions. She failed to follow her chief judge's directives. She failed to follow established court procedures, and she failed to cooperate with SCAO, all of which constitute a violation of Canon 3B, which is the crux of the charge of count 3 for failing to diligently discharge administrative responsibilities. But her conduct toward Judge Blount and Judge Peruke also constituted a violation of Canons 2B and 3A14 for failing to treat people with courtesy and respect. So the January emails with Judge Peruke coincide with Judge Davis returning to the bench on January 22nd, 2019 on the business license docket. Now, we heard from both Deanne Drew, who was the courtroom clerk, as well as Morgan Hairston, the security officer, that they saw Judge Davis disconnect the video recording equipment on her bench. And while there were some differences in their descriptions of what they observed in the courtroom that day, they both testified that Judge Davis approached the bench from the back door, got down on her knees, and pulled out the cords of the video equipment. They never wavered in that description at any time. Ms. Drew also testified that Judge Davis said, "They're not recording me, I don't trust them," referring to the court's administration. When Judge Mullins discovered that the proceedings were not being recorded and reported it to her supervisor, Shannon Walker, there was the initial wait and see approach until it happened again, which it did. Attorney Walker then stated that she went to talk to Judge Davis about the lack of recording, and Judge Davis's response was, "Yeah, I unhooked that shit," and motioned her arm toward the jury box where Ms. Walker saw the video equipment. Now, we obviously know that Judge Davis conducted several days of proceedings with no official record. And Judge Mullins spoke to this as well as the inability to file an appeal in one matter because of the lack of a record. And yet Judge Davis did record the proceedings on her cell phone, as testified to by Ms. Drew and also by Attorney Walker, who viewed some proceedings on Judge Davis's Facebook page. Judge Davis has admitted in her answer to paragraph 192 of the complaint that she recorded 32 hearings over which she presided on her cell phone in January and February of 2019 without authorization as required by Canon 3A11. Because of this failure to properly record the proceedings, Judge Blount once again removed Judge Davis from presiding over 36 district court cases in an order entered on March 4 of 2019. Now, as far as the lack of training regarding the video equipment, that is simply a red herring. Judge Davis disconnected the equipment and proceeded to hold hearings knowing full well they weren't being recorded. She didn't ask for training from Judge Blount or court administration. And Ms. Drew clearly stated that she didn't call for training, she called for a court reporter. This red herring concerning the lack of training was exacerbated by Mr. Schwartz when he asked Judge Blount if she was familiar with the audio and video recording operating standards established by SCAO. He specifically referred to Chapter 3, Section B2C. And this addresses training for a video operator and was applying those standards to a judge. Now, Judge Blount's response was that she was not so sure that those standards apply when a judge uses the equipment. And that's exactly right, because in reviewing the SCAO standards to which Mr. Schwartz referenced, which are called the Michigan Trial Court Standards for Courtroom Technology, the video operator referenced in Chapter 3 is not the judge. This is made very obvious by Section B2B, which states that one responsibility of the video operator is to play back recorded court proceedings as directed by the judge. And Section D, which begins by stating that the operator must operate the equipment as directed by the judge. And lastly, Section E, which sets forth the courtroom checklist for the judge. So then we move on to the handicap parking space violation. This count is not about a parking ticket. It's about Judge Davis's conduct. She clearly knew that she parked her SUV illegally, as we know from the statements she made to Attorney Walker and to the police officer, Nathan Gianni. She misused a Detroit Police Department placard in the driver's side window of her car to avoid getting a ticket. And although she wasn't asked to show it, she showed Officer Gianni her badge and court ID. So it can be inferred that this was done in an effort to avoid being given a ticket. Judge Davis then speaks to Ms. Starkey using vulgar and crass language, as testified to by Ms. Starkey. And she even threatened Ms. Starkey, who testified that Judge Davis said, "I'm going to get my people in court on you, you stupid bitch." And this is said to the person whose car that Judge Davis blocked from access on the driver's side. Judge Davis then requests a formal hearing where she's disrespectful toward Judge Crott. She raises wholly frivolous issues to get an adjournment. She even tells Judge Crott that she does not know anything about the witness, Cassandra Starkey. Yet the only two witnesses who testified on Judge Davis's behalf both testified about Cassandra Starkey. And then when Judge Crott asked Judge Davis if she would be asking any questions of Ms. Starkey at that hearing, Judge Davis says she's going to file an appeal, which of course she never filed, and simply walks out of the courtroom. At no time did Judge Davis ever state that she had to leave because of her docket. It's also noteworthy that Judge Davis testified that Judge Crott would not allow the parties to meet to resolve the matter. That claim was directly refuted by Judge Mullins, who stated that no such meeting was ever requested, so Judge Crott didn't deny anything. And it really has to be asked, does it even make sense that a judge would deny the parties an opportunity to resolve a matter? So the crux of the charges in count 6 have been proven by a preponderance of the evidence. Those being that Judge Davis misused her judicial office in violation of Canon 2C, that she failed to respect and observe the law and failed to treat persons with courtesy and respect in violation of Canon 2B, that she was undignified and discourteous toward the tribunal in violation of MRPC 3.5D, and that she generally exhibited a lack of personal responsibility. Now, as for the misrepresentations charged in count 7, I've already addressed that Judge Davis did indeed receive training contrary to her claims. Judge Davis's statements as set forth in the complaint regarding the video recording equipment have all been refuted by Judge Mullins, by Shannon Walker, and by Dion Drew. As for the handicap parking space matter, Judge Davis clearly misused a Detroit Police Department unofficial business placard in her car window to avoid being given a ticket when she knew she was illegally parked. And perhaps most incredibly, Judge Davis continued to maintain, even at the hearing, that she was loading and unloading her walker, which somehow gave her permission to park in that spot or somehow justified parking in that parking spot that is obviously not for parking and where she knew she was illegally parked. So based on the evidence, Judge Davis has made intentional misrepresentations and misleading statements. I'd like to close by stating that we are not here for punishment. We are here to protect the integrity of the judiciary. I'd like to thank the master, Judge Stevens, for your time and effort in this important matter. And I ask that you find the misconduct, as it has been alleged in the complaint, has been proven by a preponderance of the evidence. Thank you.
Judge, you are muted.
That's true. On behalf of the respondent, please.
Thank you, Your Honor. The Judicial Tenure Commission has spent 5 years in seeking to have Judge Kalilia Davis removed from her position as a 36th District Court judge. Count 1 involved of contempt. There were 2 individuals, Joy Eck, an office manager of Detroit Real Estate Incorporated, and Jerry Johnson, a process server, who were seeking the eviction of Sharon Hayes. Eck left an eviction notice on the property that Miss Hayes resided at. Eck's notice stated that the court ordered the bailiff to evict Hayes. In fact, such notice was a misrepresentation, inasmuch as the court had not entered such an order. Judge Davis ordered Eck to appear and show cause why she should not be held in civil contempt. Neither Eck nor Johnson testified at these disciplinary hearings, nor was there any testimony from Judge Baltimore, who dismissed a contempt charge against Johnson. The fact that Judge Davis may have erred in connection with the contempt matter does not constitute judicial misconduct. Error by a judge does not necessarily warrant the type of situation that we're dealing here as a disciplinary matter. Count 1 does not warrant the finding of judicial misconduct, and it should be dismissed. Count 2 involves Myron Bell, a court officer who serves as a process server. In this manner, Bell signed a proof of service alleging that he served a summons and complaint at a property at 430 Frederick in Detroit. At the disciplinary hearings, Bell admitted in testimony that he signed his name to a proof of service for a summons and complaint that he never served. He did not know who served the summons and complaint, but he did know that he did not do it. More than that, he did engage in his common practice of serving a summons but signing the proof of service anyway. He admitted that in at least 5 or 6 times, he had falsely claimed to have served process. When someone engages in false attribution on more than one occasion, one's credibility, reliability, and trust is subject to a lack of trustworthiness. Inasmuch as the system of justice depends upon veracity of those who appear before the courts, it is understandable that one who is a judge may do something to prevent defilement of the judiciary. Judge Davis had a good reason to believe that Bell was unreliable and dishonest, as confirmed by Bell's testimony, admittingly falsely signing his name to a proof of service in which he had no participation in the service of summons and complaint. The better course of action would have been for Judge Davis to have had higher authorities than to ban Bell from her courtroom. Judge Davis's mistake does not warrant the finding of judicial misconduct. Count 2 should be dismissed. Count 3 alleges an obstruction of justice of court administration in the 36th District Court. Initially, in paragraphs 134 through 153, the Second Amended Complaint spends a significant amount of time in referring to Bible verses that Judge Davis wrote in emails to Judge Nancy Blount, with copies to Judge Paul Peruk, 36th District Court Administrator Kelly Owen, and to Stephen Chaco, one of Judge Davis's then attorney. Judge Davis did not articulate anything in connection with the Bible verses. Judge Peruk testified that he received a number of Bible verses, of which each Bible verse was its own separate response. He testified that Judge Blount wanted to have Judge Davis report for work, and Judge Davis responded with a Bible verse. Judge Davis testified that she sent the Bible verse through email that set forth that Judge Davis came to work, was in the 36th District Court building, and the email gave the day and time. With respect to the Bible verses, Judge Paruk testified that he took them to mean that the individuals to whom the emails were sent were bad people, wicked, wrongdoers, vile murderers, sexually immoral, and the father of the devil. Judge Paruk also felt that verses were threatening, disrespectful, contemptuous, frustrating, and disappointing. When asked if he knew what Judge Davis was thinking of when she simply put a Bible verse in an email, Judge Paruk stated that he could only give his own interpretation. He stated that he made a conclusion. Clearly, the Bible verses say what they say, and there is nothing in the verses that speak to Judge Paruk or to Judge Blount or to anyone who received the email. Judge Davis was merely exercising her First Amendment rights, not only for freedom of speech, but also for freedom of religion. Judge Davis never sought to make harmful statements against anyone. All she was doing was to quote verses from a Bible as a means of letting the 36th District Court know that she was in the courthouse. Simple citation to the Bible without malicious assertion targeted against any individual does not provide a basis for finding judicial misconduct. As to the presence of Judge Davis for work in the 36th District Court, she suffered from much medical problems that required her to undergo surgeries, treatment for serious infections, and other indisposition that damaged her health, resulting in physicians requiring that she not be at work for periods of time. Judge Paruk testified that Judge Davis alerted the 36th District Court of medical problems that required that she be away from her work. Judge Paruk testified that a judge who must take a day or days off due to sickness was okay. The claims under count 3 of the second amended complaint should be dismissed. Count 4 refers to conducting proceedings without an official record. The situation involved the inability for Judge Davis to obtain assistance from the 36th District Court administration. Judge Davis had been in more than one courtroom, all of which used court reporters, except when Judge Davis was in courtroom 340. Judge Blount testified that Judge Davis should have been trained as to the video equipment in room 340. However, in further cross-examination, Judge Blount stated that she did not know whether Judge Davis was trained as to operation of the equipment. Dion Drew, who was Judge Davis's courtroom clerk, testified in direct examination that she did not believe that Judge Davis was trained in how to operate the video equipment. It is hard to understand how Judge Davis would be able to operate the video equipment if she was not trained as to how to operate it. Judge Davis testified that she was not provided with training for operating video equipment. In fact, there was no witness who stated that Judge Davis actually had been trained to operate the video equipment. With respect to the claim that Judge Davis had disabled the video equipment in room 340, Dion Drew claimed that Judge Davis disconnected the video equipment and that Joyce Thomas and Pam Triplett, supervisors of Drew, saw Judge Davis loosen the video equipment under the judge's bench. However, court investigators concluded that Drew's claim of Thomas and Triplett seeing Judge Davis disabling the video equipment was false, in which the following was stated by Parnell Williams, 36th District Court Human Resources Deputy Director, as follows. Quote, "You claim that Ms. Joyce Thomas and Ms. Pamela Triplett saw Judge Davis disconnected the video equipment as an excuse for why you failed to notify anybody. Upon further investigation, the court finds that your claims regarding Ms. Thomas and Ms. Triplett are not credible. In fact, the court has determined that these claims are completely false. And that's in Exhibit E. Dion Drew also claimed that she herself saw Judge Davis disabling the equipment. Drew alleged that Judge Davis was on her chair and got down on her knees quickly. Drew said that Judge Davis was on the bench's chair, and from there her knees were on the floor. Drew testified that she knew that it was important to have the equipment operate, but she did not do anything to alert anyone that the video equipment was not operating. Drew also was asked the following question and gave the following answer, quote, "It took all that time to get off the chair, get on her knees, pull out the plug, and then real quickly get back in her chair, all in a matter of seconds, correct?" Answer, correct. I didn't time it. Then only a few minutes later, when the JTC attorney engaged in redirect examination, Drew changed her story and said that Judge Davis did not sit in the chair. Then on recross examination, Drew said that Judge Davis took 2 to 3 seconds to kneel. Then Drew claimed the following. Question, from the time that she got off the chair, doing all the stuff that you said, getting back up on the chair, how long did it take? Answer, it was quick. Question, how long? Question, it was not slow. I'm upset, this is it, and that's what happened. Question, so you were saying 3, 4, 10 seconds? Answer, seconds. Question, seconds? Answer, seconds, not minutes. Drew again changed her story by stating as follows. Question, how long did it take for her to get to her knees after she got to that spot? Answer, I didn't count the time. It was not long at all. It didn't take that long. I'm sure it took her a minute to get up, but it didn't take that long. It is pretty clear that Drew makes statements that change whenever she wants to change them. As to Drew seeing Judge Davis allegedly get on her knees below the bench, Drew would have had to have needed X-ray vision. 4, Drew would have had to have looked through the wooden barrier of the bench, which was inaccessible. In essence, what Drew stated cannot be given credence. Drew's friend, Morgan Hairston, was a security officer at the 36th District Court. She had been assigned to Judge Davis's courtroom 340. She testified as follows. Question, can you describe what the video equipment looked like? Did you ever see it yourself? Answer, no. Besides some course, I didn't. No, I didn't. She further testified as follows. Question, what did you see? Answer, she was like pulling the cords. She was pulling the cords off of her. I don't know if it was a mic or I really don't know what it was, but she was like messing around with them. Question, all right, well, let's talk specifically about what you saw. Where was the equipment that you say Judge Davis pulling the cords or messing with the cords, as you put it? Where was it located? Answer, well, they had the cords on the floor. They had them, I guess, on her desk or something. Question, was it up on the bench's desk? Answer, yes, on her bench. Sorry, I couldn't really see up there all the way. Because I was working on the side. Question, all right, I want you to describe specifically what you saw Judge Davis do with regard to the video recording equipment. Answer, I guess I don't know what she was doing with it. I don't know if she was trying to. I just don't know. But she did get down and messing with the cords or disconnecting them. Hairston could not see the floor under the bench because there was a barrier around the judge's bench that prevents one from seeing the floor. All she knew is what she kept on saying, to wit, the judge was messing with the cords. Her claim that she saw cords under the bench is not realistic from the vantage point at which she was located. Hairston testified as follows. Question, Okay, when you were sitting with your desk, what exactly did you see Judge Davis do? Answer. She was just messing around with the cords. Just question. What do you mean by messing with the cords? Answer. Like I said, I couldn't really see up there. Like I wasn't up there with her, so I don't know what she was doing with the cords, and I don't know how, why. Question. How did you even know that she had cords if you couldn't see it? Answer. Because I had been there while the iTech team was coming in and back and forth to try to install the video or get it up and running. Question. If they weren't in the courtroom, were they? Answer. No, they were not. Now, Hairston had another statement to make. Question. And so now we have a situation where you say that my client did something. Did she kneel down? Did she jump down? What did she do to get to the so-called cords? Answer, she knelt down out of her chair. And question, out of her chair? Answer, yes. I know there were cords because I saw them put the cords there. Question, so she was first in the chair and then she went down to get the cords? Answer, yes. Question, now how did she lean over the chair or did she kneel down on the floor? Answer, she probably had to do both, to lean up a little and kneel down a little, like maybe use her. Question, did you see that? Answer, yes. At this time, Hairston came up with another statement. Question, you say now that you saw it before you said you didn't really see it. So I'm asking again, did you see her actually do anything with the video equipment cords or other kind of stuff like that? Answer, yes, I did. Okay. Answer, I said I couldn't see it clearly, like I was not standing directly next to her. Question, well, you were sitting at the time, weren't you? Answer, yes, I was sitting. Question, so you weren't standing? Answer, yeah, well, I wasn't near her, basically. I wasn't near her. I wasn't sitting close to her, and I wasn't standing close to her, but I was able to, I could still see her. I could see the clerk. I can still see a look like, how can I see the judge right now? How I can see the judge right now. I can see her. I can see her. Hairston's testimony lacks credibility. The claim that she could see what was going on below the bench that could not be seen while sitting at her desk is impossible. The 36th District Court Administration was aware that Judge Davis was not trained for video equipment. They refused either to provide her with training or else with court reporters. They did neither. Of the 28 judges in the 36th District Court, 25 did not use the 25 machines in their courtrooms. Of the 3 judges who were elected in 2016, Kenyatta Stanford Jones, Austin William Garrett, and Cornelia Yvette Davis, only Judge Davis did not have a court reporter. The JTC places blame on Judge Davis, stating that she did not personally contact Judge Blount about training or court reporters. The JCT places blame on Judge Davis, claiming that she did not direct her clerk or secretary to contact the 36th District Court Administration. Yet Judge Davis did direct her clerk, Dion Drew, to contact the administration for help. Drew testified that she was directed on numerous times by Judge Davis to obtain a court reporter. Trial courts that use video recording equipment must adhere to the video recording operating standards published by the State Court Administration Office. Among those standards are the following, and I quote, the video operator must receive initial hands-on start-up training and follow-up training from the digital recording vendors and court staff on startup procedures and advanced features of the system. The video operator should also be trained by court personnel on courtroom procedures and storage responsibilities, including, and among them was, basic training on operation. The aforementioned standards require that the trial court adhere to the same. It is clear that the 36th District Court did not comply with standard Section 1, Chapter 3B2C. It is equally clear that Judge Davis was not given the training as set forth in that standard as required by the Michigan Supreme Court. As such, Judge Davis should not have been the subject of the 36th District Court administration's failure to provide her with training or to provide Judge Davis with court reporters, neither of which was done. Given the foregoing, count 4 should be dismissed. Count 5 involves unauthorized recording of and publication of court proceedings. Shannon Walker, a staff member of the City of Detroit Law Department, testified that there was a black box that was a video recording equipment that was in the jury box at courtroom 340, where Judge Davis was presiding. Ms. Walker also testified that in the beginning of 2019, she looked through Facebook and saw Judge Davis with a camera that pointed to her face and her calling cases. By the way, I should point out, the jury box, there's nobody other than Ms. Walker who said that any of the video recording equipment was in the jury box. Ms. Walker said she was looking through Facebook and saw Judge Davis with a camera that pointed to her face and her calling cases. She further claimed that she heard Ms. McMullen's voice, and Ms. Walker stated that she told Mullins, that she heard her voice from Facebook and she thought it was being put on Facebook Live. Ms. Mullins, now a 28th District Court judge, was a witness for the JTC on July 13, 2022. Judge Mullins said nothing about Judge Davis's having a court hearing on Facebook. The JTC did not seek any testimony from Judge Mullins as to any recordings on Facebook. Curiously, no alleged Facebook page of courtroom proceedings purportedly from Judge Davis was presented. No confirmation by Judge Mullins, who was present at the JTC hearing, was adduced at the hearing on July 13th, 2022. Accordingly, there was no physical evidence from anyone and no testimony supporting Ms. Walker's claim that Judge Davis published a court hearing to Facebook. It should also be remembered that Ms. Walker testified that the video recording equipment was in the jury box. Such a claim is incongruent with all of the evidence that was elicited in the hearings. Ms. Walker also claimed, with respect to Judge Davis's vehicle being at the Blue Stripe park space in the parking lot near LA Fitness, she saw a security guard taking pictures of the vehicle. However, Cassandra Starkey stated that she took a picture of Judge Davis's vehicle, which she said was taken before the police officer arrived. Accordingly, it was Cassandra Starkey who took the pictures of Judge Davis's vehicle, not a security guard, as Ms. Walker stated. Thus, Ms. Walker appeared to be unreliable as to her claims without confirmation from any other source. She does not warrant reliability and confidence. Given the foregoing, count 5 should be dismissed. Count 6 deals with a parking violation. Judge Davis parked in a space that was identified by blue stripes. Judge Davis has a license plate that signifies that she is a person with disabilities, as well as a tag for the front windshield from the Michigan Secretary of State that indicates that she is a person with disabilities. Judge Davis's vehicle was in a space that was for unloading and loading for people with disabilities. She was unloading her walker from the vehicle and then loaded the vehicle with that same walker. Police officer Nathan Gianni arrived at the space where Judge Davis's vehicle was located. He performed a lean run of the vehicle and determined that the vehicle belonged to Cornelia Davis. Judge Gianni viewed a placard on the driver's side window. When asked on cross-examination whether that placard meant something to him, he stated that it meant nothing. He stated that the placard did not confer any authority on Judge Davis to park in the blue striped space. Officer Gianni asked Judge Davis if the vehicle in question was her vehicle, and she stated yes. He then told her that it was illegal to have parked her vehicle in the space, to which he testified that she stated, quote, "I know." Officer Gianni asked Judge Davis if she was on official business, but he could not recall her answer. Officer Gianni indicated that he had no intention to impound her vehicle. Officer Gianni acknowledged that Judge Davis had the right to park in a handicap space, just not in the blue stripe space. There was no indication that Judge Davis engaged in any impropriety in connection with Officer Gianni. Even if Judge Davis was not in compliance with that statute and had a parking violation, such does not constitute judicial misconduct. As to Judge Davis's event before Judge Alexis Crott, there was no disrespect. Judge Davis advised Judge Crott that she could not remain because she was required to return to her courtroom in Detroit to preside over her docket that day. There was nothing in count 6 that warrants a finding of judicial misconduct. Count 7 involves alleged misrepresentation by Judge Davis, most of which is not worthy of discussion. For example, as to count 1, the JTC asserted that Judge Davis falsely alleged that she did not have proper training in connection with the contempt matter involving Jerry Johnson. Proper training would include not only being given a lot of books, but also involves the type of educational instruction that would be the equivalent of series of seminars for the new judges. Judge Blount admitted that she had given Judge Davis an abbreviated orientation, something that was much less than was provided to the other newly elected judges. And that's because Judge Davis had missed part of this in the beginning of her tenure. Such is not a misrepresentation by Judge Davis. As to count 2, claimed in paragraphs 234 to 241 of the second amended complaint, that Judge Davis misrepresented her living status by asserting that she was living at 430 Frederick in Detroit and that she was also living at another location. The JTC failed to demonstrate that Judge Davis engaged in misrepresentation as to her having living quarters there. In fact, there's nothing at all that prevents somebody from living in more than one location. There was no claim in the second amended complaint that there was a misrepresentation in count 3. As to count 4, the JTC alleged that Judge Davis engaged in misrepresentation regarding the video recording equipment in courtroom 340. Once again, Shannon Walker comes into the picture. In this matter, Ms. Walker claims that Judge Davis admitted to her of disabling the video recording equipment. Ms. Walker stated that she had to report this to the chief judge or court administrator. If in fact, Walker did make a report telling the chief judge or the court administrator that Judge Davis had disabled the video recording equipment, it would be beyond belief that the chief judge or the court administrator would not have brought such information to Paul Peruk or other authorities. And there's no indication at all in this hearing that any of that happened. However, there was nothing in any of the hearings that Judge Peruk testified of Ms. Walker's claim against Judge Davis. Given the factors in Walker's other claims against Judge Davis, this latest move by Walker is highly doubtful. Again, there is no claim of second amended complaint that was misrepresentation in count 5. And it should be pointed out that with respect to all of these things, it's the requirement of the JTC that it prove its claim by preponderance of the evidence. As to count 6, all of the claims that are asserted in paragraphs 254 to 263 are questionable at best. Carolyn Lewis, who had been a Wayne County court clerk, testified that Judge Davis is very soft-spoken, who does not use vulgar language. Lisa Favors, who was a sports referee in high school and collegiate athletic games, testified that Judge Davis is soft-spoken and pleasant to be around. She further testified that Judge Davis did not speak to Cassandra Starkey in the LA fitness pool. Ms. Favors said that neither she nor Judge Davis talked to Starkey. Judge Davis stated that after talking to Starkey at that first meeting that she met her, thereafter, she never talked to Starkey again. Count 7 should be dismissed. Judge Davis did the best that she could in her role as a 36th District Court judge. While she may have made mistakes, as virtually everyone does, she did not act in a manner intentionally designed to cause harm. Having spent her legal career mostly in criminal defense prior to being elected as a judge, she worked diligently in her judicial work. Unfortunately, she was subject to disparate treatment by Judge Nancy Blount, who was Chief Judge of the 36th District Court during the 2013 to the end of 2019. From 2017, when Judge Davis's term as a judge commenced, to the end of 2019, after which Judge Blount was no longer the Chief Judge, Judge Davis was deprived of necessities of being a judge. She was deprived of having a courtroom reporter. When in 2019, she was moved to courtroom 340, even though almost all the other judges were provided with court reporters. By being placed in courtroom 340, which was on one side of the court building, and placing her chambers on the other side of the court building, far away from courtroom 340, Judge Davis was put in a most difficult position. Inasmuch as she had been disabled long before her being a judge and continuing to the present, it was a major problem for her. Walking to her chambers from courtroom 340 caused her to become exhausted and to make it difficult for her to breathe, which I've actually seen myself when we were in the 36th District Court. The 36th District Court administration was aware of Judge Davis's plight, but did nothing to accommodate her. Now she was being investigated by the JTC for 5 years and has been suspended on an interim basis. It is submitted that the present situation should never have occurred. Even where Judge Davis may have erred in some cases that were before her, judicial misconduct is not what she committed. Now with that, Your Honor, I rest.
Thank you. Is there anything further?
Nothing further. Thank you, Judge.
Nothing further here, Your Honor.
And we will we'll reiterate that all of the exhibits, including the supplementary exhibits, were admitted, that both parties shall present findings of fact and conclusions of law to the court served electronically by noon on Friday.
And just so that I'm clear, each one of us is sending it separately, is that correct? Or are
Yes,
we doing it jointly?
each party will submit conclusions of law and findings of fact.
Thank you, Your Honor.
Thank you. With that, the record is closed.
Thank you.